Landlords. The Court of Appeals has just given us a decision that gives us guidance about who bears the burden of producing evidence regarding a landlord's compliance with Civil Code Section 1962 regarding notifying a tenant of agents of service of process management and where to pay rent to. Hi, my name is Rob Wells. I'm the landlord. We're on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, a recent Court of Appeals decision coming out of the Superior Court of California, County of Los Angeles Appellate Division, clarifies now that the tenant bears the burden of proof of showing a violation of Civil Code Section 1962, basically. And so a little bit of background on that is Civil Code Section 1962 prescribes to landlords that they must provide certain information to their tenants about management, agents of service of process, and where rent can be paid to. Okay. In all leases, a landlord is supposed to disclose this information within their rental agreement and maintain that information. Where we see a lot of landlords get into problems with is when they succeed a predecessor in interest, like they buy a property from someone, or we see property managers, they take over management from a landlord. You have to update this information within 15 days pursuant to the Civil Code section. Okay. Failure for a property manager or a successor owner of providing the notification pursuant to Civil Code Section 1962 bars that property manager or that successor owner for filing an unlawful detainer for non-payment of rent for any period of non-compliance. Okay. And we're seeing a lot of these defenses now in non-payment of rent cases. Okay. So prior to this Court of Appeals decision called 360 SO Reeves LLC versus Dutton, it's published at, it's actually a case number. It just came out February 27, 2026. I skipped all that. It's for all the legal beagles. The case number is 24 APL C00389. It hasn't made the California Reporter yet, but this case just came out, and it basically declares that the tenant, that this violation of Civil Code Section 1962 is an affirmative defense to a non-payment of rent eviction case, and the tenant bears the burden of proof. Now, why is that important? Prior to this decision, there were a line of cases that basically made it the landlord's burden to show in their case in chief that they complied with Civil Code Section 1962. And obviously, tenants would raise that each and every time in each case, and the landlord would have to bear the burden of showing that they complied. Okay, well, this case actually clarifies that issue because it wasn't clear if it was an affirmative defense or if this code section required the landlord to provide that in their case in chief in proving their non-payment of rent case. Okay. There's certain things that a landlord has to prove to be successful to evict a tenant for non-payment of rent in California. One of those items is you have to have a valid 3-day notice for non-payment of rent, and has to contain certain information like the landlord's name, telephone number, and address where rent can be delivered to. And if rent can be paid in person, the usual days and hours that the tenant can pay the rent. Okay, we're not going to get into the details of that, but this case kind of made it clear that the tenant bears the burden of proof if they want to assert this as an affirmative defense, and the court declared it's an affirmative defense. Tenant bears the burden of proof to show that the landlord has not complied with this section. Okay, why is that important? Okay, well, over the years, in recent times, we're seeing, at least personally, I'm seeing a lot of tenants raise this issue. Okay, and it's one of the big things we see landlords screw up and may not be successful in pursuing a case for non-payment of rent is compliance with Civil Code Section 1962. Predominantly what I see where we have the most problems with is naming or designating an address where an owner or their authorized agent may be served in person. for service or process. Okay, a lot of landlords will use PO boxes and that sort of thing, but you can't be personally served at a PO box or a post office box because there's no one to take any type of notice or service or process there. So that's kind of one of my the biggest things that we see is technical compliance with the statute. And the Court of Appeals in recent times has basically stated that in order to evict a tenant successfully in California, you have to strictly comply with each and all of the rules related to non-payment of rent. And because Civil Code Section 1962 Subdivision C has this this condition in the code section that says, hey, if you don't comply, you can't evict a tenant or issue a 3-day notice for rent. That's where we see tenants raise that defense. So it's very important that you have all the items needed required in Civil Code Section 1962, which basically you need to designate who's the manager, a place where they can be personally served, notices and demands, and you have to declare how rent can be paid. Okay, you have to put the name, telephone number, and address where rent can be delivered to, and if rent can be delivered in person, the usual days and hours that rent can be delivered. There's some optional things that you can do too, such as put in electronic forms of payment, how tenants can pay you electronically, or deposit rent if into a bank account of the landlord or a designated individual, so long as that bank account or bank branch is within 5 miles of the property. So there's a lot of stuff that they give you, and sometimes we see a lot of people screw it up. So it's important that you comply with these things, so when you have to do a non-payment of rent case, you can do it successfully. So landlords, if you're in the Northern California area and you need help trying to figure out what disclosures you need to give, how do you comply with Civil Code Section 1962, feel free to reach out. We might be able to help out. Put your comments, questions down below. Try to answer them to the best of my ability. Until next time, folks, talk to you then. See ya.